Every founder signs two kinds of documents with their team. The first is the one you celebrate, the term sheet, the funding agreement. The second is the one you ignore, the employment contract template you downloaded in a hurry. One secures your future, the other can quietly destroy it. You're building a multi-crore enterprise. You obsess over product, marketing, and finance. But the legal foundation connecting your entire operation, your team, is built on sand. Most Indian founders treat employment contracts like a bureaucratic chore, a boilerplate template downloaded from the internet, signed, and forgotten. This is a catastrophic, unforced error. The standard advice you find online is a fragmented checklist of clauses. It's reactive. It fails to grasp the fundamental truth. Your employment contract is not a static document. It is a dynamic operating system for your company, and it must evolve in lockstep with your company's velocity. A contract designed for a 3-person garage startup will cripple a 50-person growth stage company. The legal armor you need to protect 10 crore rupees in intellectual property is fundamentally different from the compliance basics you need to hire your first intern. It's time to forget the checklists. You need a new paradigm. The danger of using the wrong contract isn't theoretical. It's a cash-burning, focus-draining nightmare. You believe you're a small family relying on verbal agreements? That's naive. The courts have consistently ruled that even without formal contracts, workers can be granted full rights under statutory law, including reinstatement and back pay. A simple misunderstanding can become a multi-year legal battle. Think you can just handle PF and ESI compliance later? A Mumbai startup faced an FIR for EPF default, not a civil penalty, a criminal proceeding. That's what happens when compliance isn't hardwired into your legal DNA from day one. These aren't complex, high-level mistakes. These are simple, unforced errors that kill promising ventures before they even get started. And the risk only multiplies as you grow. The stakes get higher. The weapons you need change. So, how do you build a contract that grows with you? You stop thinking in clauses and you start thinking in gears. Welcome to the Employment Contract Velocity Framework. This is a 3-gear system designed to shift your contractual strategy as your business accelerates, transforming your hiring documents from a passive legal liability into an active strategic weapon. Let's engage Gear 1. Gear 1, the foundation engine. At the 0 to 15 employee stage, your primary enemy is the unforced error. Your goal isn't complex legal engineering. It's absolute non-negotiable compliance. Your strategic mandate is simple: risk mitigation. First, mandate written contracts for everyone, no exceptions. This defines the baseline of the relationship: role, remuneration, reporting. Second, codify termination and the notice period. Your biggest vulnerability is an ambiguous exit. Define a 30-day notice period. Specify grounds for immediate termination for cause like gross misconduct or fraud. This clarity prevents every termination from becoming a potential trip to the labor court. Third, embed statutory compliance. Don't just plan to comply with Provident Fund and ESI. Write it into the contract. A simple clause stating the company will make all statutory deductions creates a binding commitment. It builds trust and demonstrates intent. Finally, define a probation protocol. A 3 to 6 month probationary period is your only true easy exit for a poor fit. But it must be defined in the contract with a shorter notice period of 7 to 15 days. In Gear 1, your contract is your shield. It defends against the simple mistakes that can kill your dream before it has a chance to fly. But once you have a foundation, you need to build walls. Gear 2, the Moat Fortification, you now have between 15 and 100 employees. You have traction, you have valuable assets, client lists, source code, business processes. Your focus shifts from basic defense to active asset protection. Your strategic mandate is asset protection, and this is where most founders make a critical mistake: the generic non-compete clause. Let me be clear. Under Section 27 of the Indian Contract Act, broad post-employment restrictions on trade are void. A Delhi High Court ruling in 2025 reinforced this. That non-compete you downloaded is legally worthless paper. You need surgical instruments, not a blunt object. First, you weaponize the IP assignment clause. All IP created belongs to the company is not enough. It must be explicit, covering inventions, code, designs, processes, trade secrets, anything created using company resources or related to the company's business. No gray areas. Second, you define confidentiality with precision. Don't just say information is confidential. List it. Customer lists, financial data, marketing strategies, source code. This specificity is what gives your NDA teeth in court. And third, you deploy the smart non-compete, the non-solicitation clause. Instead of an illegal blanket ban, you prohibit ex-employees from two specific things for a reasonable period: poaching your clients they worked with and poaching your team members. Indian courts consistently uphold these targeted restrictions because they protect your legitimate business interests without unreasonably restricting an individual's right to earn a living. In Gear 2, your contract becomes your fortress. It protects the value you have painstakingly created. Gear 3, the scale protocol. You've crossed 100 employees. You are now a significant entity. Your scale attracts a higher level of scrutiny. Individual mistakes can become systemic liabilities. Your strategic mandate is systemic compliance and enforcement. The critical error at this stage is assuming your contract can override statutory law. It cannot. You cannot have an employee sign away their right to gratuity. An arbitration clause cannot block an unfair dismissal claim from going to the appropriate labor court. The Supreme Court is clear. Statutory rights trump private contracts. Your contracts must now integrate industrial law protocols. For large-scale layoffs or retrenchment, the Industrial Disputes Act kicks in. This requires government notification and mandatory severance. Your contracts and HR policies must be perfectly aligned. You must audit your employment bonds. That 2 lakh rupee bond to prevent an employee from leaving after training, it will be struck down by a court if it's a penalty rather than a genuine estimate of your actual documented training costs. Finally, you must systematize your exit and enforcement process. The contract should reference a formal exit procedure, including return of property and a data audit. This demonstrates you have made reasonable efforts to protect your trade secrets, a key factor for courts. In Gear 3, your contract is an industrial-grade compliance system built to manage the high stakes of operating at scale. The foundation engine, the Moat Fortification, the scale protocol. 3 gears, 3 stages of growth, 3 distinct strategic mandates. Your employment contract is a reflection of your strategic maturity as a founder. So I ask you, are you operating with a Gear 1 document when your business is in a Gear 3 reality? You've just learned the difference between basic compliance and building a competitive moat. You understand the framework, but theory is one thing. Execution is everything. Knowing the map isn't the same as knowing your exact location on it. A single weak clause in your IP or solicitation terms could still cost you crores, so don't guess. Know your exact risk exposure in the next 15 minutes. I've developed the Employment Velocity Contractual Risk Scorecard. It is a powerful diagnostic tool that moves you from theory to action. It will analyze your current contracts against the 3-gear framework and give you a quantitative score on their strength. More importantly, it pinpoints the precise clauses that are leaving your IP, your clients, and your talent dangerously exposed, providing a red flag analysis that is worth lakhs in saved legal fees and protected value. This isn't just information, it's intelligence. Get the immediate clarity you need to fortify your business. Click the first link in the description below to get the Contractual Risk Scorecard now.